You're watching Reality Check. Is it increasingly becoming clear that two standards seem to be at play? Swift hearings and protection from arrest for those seen as regime loyalists. For the rest, no protection from arrest, no bail. The most striking recent example, the case of the makers and cast of Tandav, who faced the prospect of arrest in multiple cases filed against them across India. And of the case of Munawar Farooqui, the comedian in jail in Madhya Pradesh now for several days for allegedly objectionable comments. Comments it's unclear if he ever made. Today, the Madhya Pradesh High Court Indore bench rejected Farooqi's bail. The court said the evidence collected suggests that prima facie, scurrilous, disparaging utterances outraging religious feelings of a class of citizens were made by the applicant. The counsel for Farooqui tried to submit that he did not utter anything as alleged. But the court said in the light of the statements of the complainant and the witnesses referred above, it's not a case of no evidence. The court went on to say that the constitutional duty of every citizen and of the states is to promote harmony. States must endeavor that the society is not polluted by negative forces. Similarly, this comes days after the Supreme Court refused to give protection from arrest for the makers of Tandav. The court rejected the plea by the Tandev cast and makers for protection from arrest. There are multiple cases against Tandev in different states, as we said. Now, lawyers for Tandev, which included Fali Nariman and Mukul Rohatgi, said that the filmmakers or the makers of the series have apologized. They've removed the content. They said that the serial is only a political satire. They said that Zishan Ayub, the actor, is just an actor under contract. The views expressed are of his character. They also referred to the Arnab Goswami case, where the court had granted protection citing personal liberty. But the court observed that freedom of speech is not absolute. They said that the actor accepted the contract after reading the script, so how can he not be liable? It also said you cannot hurt religious sentiments. Now, just to remind ourselves of what the Supreme Court had said in the Arnab Goswami case while granting him protection, it said it will be a travesty of justice if bail is not granted while the FIR is pending. If constitutional courts do not interfere, we are traveling the path of destruction. Governments should ignore them in reference to taunts on TV. We must send a message today to the high courts as well. Please exercise your jurisdiction to uphold personal liberty. If state governments target individuals, they must realize there is the apex court to protect the liberty of citizens. Now, this comes in the time when there are also questions over whether people like Munawar Farooqui actually said what they've been accused of saying. Remember, in the initial Munawar FIR, it did not name him as an accused. The police, despite the court's urging, failed to produce the case diary in court. Media reports actually suggested that the police said that the comedian was arrested for jokes he was going to make. The police later claimed that they were misquoted. Also, when one looks at some of the evidence that the police has submitted in court, it appears to be copy-paste. The witness statements are almost exact copies of each other, witnesses making near identical statements claiming to have heard Munawar practicing the offensive comedy routine, not actually making it. Let's just put those two statements side by side. These are by two individuals side by side that you can see on the screen. One is by someone called Kunal, the other is by Shubhendra. We've translated this from the Hindi, but it's exactly line by line almost the same. 5 of my friends and I were told that we should get tickets after paying a boy named Edwin. Then friend Eklavya and I paid rupees 2,000 and bought 4 tickets. Shubhendra and I stayed outside and stood in the gallery. Just then the show started, and outside Munawar Farooqui began practicing and sang a song using extremely objectionable words for Lord Ram and Sita. There also appear to be, in addition to this, contradictions in these statements. The complainant in the case, who is the son of a local BJP leader, says the offensive comments were made on stage by Munawar. The witnesses, though, are now saying that the offensive comments were made by him during the rehearsal. Similarly, in the case of Tandev, it's really a question of whether this is herd sentiment or is it politics. It's largely either BJP-ruled states or BJP netas who've taken a lead in filing FIRs. This despite multiple apologies by the Tandav team and by editing out those portions considered offensive. The BJP netas are pointedly naming the minority members of the cast and the crew when they're making these charges. The question was, what is the offensive part? That a character who plays Shiva in a play says the term Azadi, which has sparked this outrage, raising the question, is this manufactured outrage for political gain? Joining me tonight on the reality check, we've got a great panel. We've got Vivek Tankha, Rajya Sabha MP for the Congress Party, but who also appeared in the Munawar Farooqui case. Pinky Anand, Additional Solicitor General of India, is with us. Siddharth Luthra, Senior Advocate Supreme Court. Another Senior Advocate Supreme Court, Arima Sundaram. And Gautam Bhatia, who is a lawyer, author, one of the foremost commentators on Indian legal system, joining us. Let me just start with you, Gautam Bhatia, because much of what I've spelled out, you've been tracking for a long time. And in fact, Gautam Bhatia, you've even have summarized many of these instances in your Twitter thread, where you call it, "Show me the man and I'll show you the law," implying that there are different standards at play.
Yeah. With respect to the Munawar Farooqui bail, I think it's a travesty of justice in every respect. In a bail hearing, the only things the judge should be taking into account is whether the accused can tamper with the evidence, can influence witnesses, if the accused is a flight risk, and yes, the gravity of the offense. Nothing beyond that. And the judge's statements, oral statements in this case, as reported, seem to reflect a prejudgment on the merits of the case that seems to have then influenced the decision to not grant bail. And if you put that against the Supreme Court's observations in the Arnab Goswami case, stressing on how bail is the rule and jail is the exception, and the importance of bail, and that even one day behind bars is a day too many, the contrast is quite stark.
Right. Vivek Tankha, because you actually appeared for Munawar Farooqui. Now, overall, this idea that we heard in the Supreme Court saying that you must respect liberty, individual liberty, very important, and yet increasingly the trend seems to be going in a different direction.
Vasu, I must say to you that it's very worrying to find the kind of constitutional governance we are heading towards. Are we looking for an inclusive or a divisive society? That's the question. If everything that is divisive gets promoted or projected, and sometimes the portrayal is so incorrect that it's frightening that what are we doing to our country? I know cases. Forget Munawar Farooqui, that's one case where you said, I did not utter a word. That's his statement, and that's what the police said next day in the newspapers. He now is being punished for something which he had said on a video 18 months back. So, and the BJP activist, of course. But even more shocking, today the way sections 153A, 153B, 295A, sedition, I have never seen such blatant misuse of these sections in other. Today, from Uttar Pradesh, where political leader makes a public statement in the month of August, and 6 months later, FIRs are getting registered periodically that he has in the 153A, 153, that's getting
right. Okay.
So what is happening is that are we losing this trust on governance? That is the main issue, because if people lose trust in the systems, then our democracy is in peril.
Okay. Pinky Anand, just moving away from the specific individual merits of these cases, did person A, B, C say it or not, if one just looks at the overall principles set by the highest court itself, that's the question which many are asking of whether different standards are at play. In Arnab Goswami case, the court gave the protection saying will be a travesty of justice if bail is not granted while FIR is pending, if constitutional courts don't interfere travelling on the path of destruction. But when it comes to others, Pinky Anand, it seems to be a very different set of responses.
Vasu, I'm afraid that you cannot take particular lines from a judgment in respect of, for example, Arnab's case and transport them into and hope to translate them across board. Bails in any case are specific to, principles are there, the common principles across board.
I'm on the principle. I'm on the principle.
No. Just let me get there.
Yeah.
So you do have principles which are established for bail. For example, tampering of witnesses. For example, the investigation is pending. For example, the material seized. For example, the gravity of the offence. For
Yes.
example, the threatening of witnesses. All that is settled law
Yes.
by now, and this is hardly open to any issue.
Right.
How it has been done, for example, in Arnab's case was in the backdrop of that case where there was an issue, and I don't want to go there for a moment. But coming to the case at hand, we are talking about some of the observations which the judges made, the single judge made,
Yes.
while declining bail.
Yes.
And if you look at the reason why he actually declined bail, and that is somewhat interesting, is that the evidence and material collected so far suggests that in an organized public show, under the garb of stand-up comedy at a public place on commercial lines,
Yes.
prima facie, scurrilous, disparaging utterances, outraging religious sentiments with deliberate intentment were made by the applicants, and
Right.
the court said, in terms, whatever I have said, be that as it may,
Yes.
this court refrains from commenting upon contentions of the parties, but regard having been made to the material seized,
Yes.
the statement of witnesses, and that the investigation is in progress, no case is made out for grant of bail.
So this is what
so,
No, this is the
So,
point
let us
here.
not-
But isn't there? Hold on. Isn't there a contradiction? One second, Pinky Anand, hold on. On one hand, the court says that we will not get into merits. Then also goes on to say, prima facie, we do appear to find that these comments have been made. As we've just seen from the FIR itself and from the statements, there are serious question marks over whether the prosecution has been able to provide evidence of whether these comments were made or not. The case diary was not even submitted to the court, though the court themselves insisted on it. So I'm saying in such a situation, when you've already laid down certain principles about travesty of justice if bail is not granted while FIR is pending, A read with B, and yet you deny bail.
Vasu, again, as I said, you can't read A with B in that fashion and translate it across board. In Arnab's case, just for a moment, since you are talking about that case and the lines from that judgment which talk about constitutional courts exercising rights of liberty, it was a case where the case had been closed, reopened, and nothing happened thereafter. The fact that he was put behind bars in the situation that he was, the entire manner in which it was done, and in those circumstances, what the courts hold regarding liberty, of course, and there is no ambiguity whatsoever on that liberty issue. But you have a case as at present for a moment. You have investigation going on. You have, as far as the court is concerned, the gravity established from the statement of the witnesses as the court has held. And in these circumstances, the bail has been denied, including the materials which have been already searched and seized.
Right.
So, you can't translate that across board. Otherwise, as a matter of law, you could say, and possibly that is what you are trying to say, is that bail should be granted in all cases. It can't.
All right. Siddharth Luthra, your thoughts on this. Are you also concerned about how the pronouncements are coming when it comes to these questions of,
Vasu, you're a little
freedom
faint
of
there. Can you
speech?
just be a little louder? I can't hear you.
Yeah, Siddharth, is this better now? Can you hear me now? Is this slightly better?
A little better, yes.
Okay, I'm just asking, are you concerned also about the manner in which there does appear to be different kinds of standards and pronouncements of who gets bail and who doesn't, and especially on questions of
Vasu,
freedom
I
of
will,
speech, especially when it comes to freedom of speech and personal liberty? Yes.
I must tell you very clearly, I've appeared in a number of these cases, including Amish Devgan and Tandav, and I made it clear I will not speak about cases which I have done, and therefore I don't want to. It's
No,
not
I'm
appropriate
asking
for
you in a
lawyer
general
to
sense.
respond.
I'm not asking you. I'm asking in a general
Vasu,
sense. Yes.
Vasu, please listen to me. I thought the question was put to me, so you have to listen to me.
Yes.
The concern that I had, as raised by Gautam Bhatia, was that there is one thing that you record an FIR and you investigate a matter. After all, what is it? It is a one-point incident. The incident has taken place, whatever it may be. It is not a murder case. It is not a case which has a death sentence or a life sentence. The point is, an incident takes place. In para 14, the Honorable Judge has taken a view that investigation needs to be gathered. Now, frankly, that was not a reason to keep this man in judicial custody. He was in police custody. He was there calling for the case diary. Is legitimate. In fact, the police are supposed to produce the case diaries. The judges to look into them. There's no doubt in that. But my concern is, should high courts be declining bail in matters where the incident got over a while back? There is no requirement, no justifiable requirement to say that investigation is pending. It may be pending, but not against this man. And that is my concern. We have to go back to the era when we were more liberal towards bail, where the presumption of innocence, which attracts to this man, attracts to every Indian, barring few statutes. And that is the concern. It is a larger issue which we need to address. We have to go back to an area of libertarian jurisprudence where bail was a right and refused jail was the exception. That's the concern, and that is a concern we should be talking about.
Okay.
For me, liberty is the most precious right. We can't have it curtailed because the high courts are our constitutional courts. They are supposed to protect us.
Right. Arima Sundaram, you agree? Arima
I
Sundaram?
couldn't hear what Siddhartha was saying,
Yes.
so I can't agree or disagree. But my own views on this are, I must say that when I did read about the judgment of the High Court, I was very surprised because I cannot begin to even try to agree with the judgment. I believe the judgment, either what I have read in the law books, in my days, laid down principles which appear to be different from the principles I saw being used in the judgment, or the law itself appears to have taken a different course today, where bail seems to be an exception and jail the rule. I'm going so far as to say, let us assume that the prima facie case was made out. Here, of course, the High Court seemed to feel that he has not done anything to show he was not going to do it, which I found was a negative which can't really stand. But being as it may, let's assume a prima facie case was made out. Let's assume that case has been made out, that it bears further scrutiny. What was the reason for not granting bail? Where was the finding that he was going to escape from justice, that he was going to tamper with investigation, that he was going to tamper with the witnesses, that he was otherwise going to obstruct justice? This is a case where bail, I believe, even if prima facie it was felt that the offense was made out, ought to have been granted. Now, the reason I'm saying this is, it's indeed becoming a worrisome fashion in India that more and more cases, opinions, personal opinions, when affronted, appears to become a cause of action of filing a complaint against a person, accusing them of affronting religious sentiments or affronting other feelings or communal feelings or whatever it is.
Right.
We must realize that, yes, there are restrictions on freedom of speech, but the restrictions are an exception. The rule is freedom of speech.
Okay.
The rule is freedom of expression.
Right.
And yes, that does not mean it's untrammeled and you can say what you want, where you want, irrespective of the laws.
Right.
But the fact is those exceptions have to be very strictly enforced.
Okay.
And today I'm afraid the exception is becoming the rule and the rule the exception.
Right. You know, Gautam Bhatia, as you were pointing out, it's one thing to actually look at the exact judicial arguments or logic used, but it's also the comments that are made which are increasingly creating confusion about, is this purely within the realm of jurisprudence, or this is almost becoming a kind of social commentary, like in the case of Munawar Farooqui, where the court said things like, someone like this must not be spared. Why do you take advantage of others' religious sentiments? What is wrong with your mindset? Things like that.
I think with the initial caveat that because we don't yet have a situation where we have a live streams of proceedings, we go by what the report is from legal reporters who are on the spot.
Yes.
So a lot.
This is from live law and so on. Yes.
Yes. So with that caveat, I want to put that on record. But yes, this is a little disturbing because it reflects the attitude that the judge in question is bringing to adjudicating the case. In that sense, these oral statements that may have been made in the heat of the moment, that may have been made in response to a back and forth, but nonetheless they are still reflective of how the judge perceives that case. And I don't here mean questions the judge puts to counsel to bring out, say, the weakness of their case or to push the case. I don't mean those kinds of questions. I mean a clear statement of opinion that the judge makes, such as these people should not be spared, or as in the Tandav case, where there was a conflation between the actor and the actual person. And I think that the concern I have is that what is coming out from statements of this kind is that the courts seem more keen on providing a moral lecture that is based on their personal sense of what is right and wrong, as opposed to adjudicating the case before them on its legal merit.
Pinky Anand, your take on these comments? That is it unfortunate?
No, I'll tell you one thing. I don't think this practice of getting into the comments made by a judge during the course of arguments, and that also partial comments, is something that should be commented upon. I would be very unhappy about doing it till I know exactly what has been said and in what context and what in response to what. Having said that, I think the judgment is what one needs to see, and the judgment is there. As I read out to you the specific portion which dealt with investigation pending and the material seized and the gravity of the offence. Now, this broadly covers the field as far as declining or rejection of a bail is concerned. There could be other grounds. So, I think we stick with the judgment and we don't go into the arenas of what kind of comments were made out of context or within context. You know the full happenings, and it would not be proper to do so.
Okay. Vivek Tanka, as we wrap up on this show, what are the options then really for ordinary citizens or even not so ordinary citizens, when they go to seek some kind of relief in these sensitive matters from the higher judiciary, and then we are seeing the kind of response? What do you do?
Srinivasan, I'm reminded of those famous words of Justice Hidayatullah in the 60s when he was hearing a case on that book, I think Lady Chatterley's Lovers. He said, no book is good or bad. Book is either well written or not well written. So, frankly speaking, artistic freedom of speech, Article 19, that is ingrained in our constitution.
Right.
Bail is the rule, and jail is an exception. Now, my problem today is when I see that the difference that we used to notice in the 60s and the 70s and the 80s in the approach of the police and the court.
Yeah.
That was a big difference. Today, that has narrowed down.
Right.
Now, that is frightening. That is frightening because that is where the liberty of a citizen comes into question.
Right. And Siddharth, the same question, because you all pointed out how things were different earlier. There was a more liberal or more libertarian approach. But as I was pointing out, it's not as if people are not getting relief now, but it seems to be selective.
We have over the last many decades enacted harsher laws.
It seems to be selective.
From the mid-1970s.
Yeah.
Sorry?
I said...
I was saying that since the mid-1970s,
yes, go ahead.
The approach to bail has got constricted. We have enacted harsher laws. We have reversed the burden of innocence even at the stage of bail. And this needs a serious rethink, and it has happened across administrations. You can't blame one and the other administrations because this has happened, and any student in law will tell you over the last 5 decades. So it is time now for, as lawyers, as citizens, as thinkers, to get back and say the law needs to be analyzed. Is this the way we're going, where we're going to keep our jails full?
Right.
I think not. I think it's time to say we have to have a positive approach and respect the presumption of innocence and liberty. That's a fundamental premise of our constitution. We're forgetting that, and we need to look at that.
Mr. Sundaram, the same question I asked Vivek Tanka, what's the recourse then? Because if this is the response one gets from the higher realms of the judiciary, where does the person go?
Well, I don't think you need to take it that way, Srinivasan. I'll tell you why. The law is in the law books and in the Constitution, but the dispensing of law is in individual judges. Now, you must realize one thing. Every judge does his utmost to render the justice the way he sees justice needs to be rendered. There's no manner of doubt there, and that's a greatly encouraging factor in our country.
Right.
The fact is different judges have different attitudes to things like crime, to grant of bail. Some are more averse to grant of bail, some are more likely to grant bail as a philosophy. Now, whether you like it or not, the rule of law allows a dispensation of law by judges and allows for play of a judge's philosophy.
Right.
Which is why your feeling that there are different cases, different judgments in different cases may not be apposite. Because it's actually the philosophy of a particular judge which comes out in his judgment.
Okay.
And I cannot find fault with that because that is but human. And law is dispensed by human beings.
Okay. Well, we're out of time. In individual instances, you're right. If one person goes in one direction and the other in another, that's fine. But as the work of people like Gautam Bhatia has pointed out, there has been an increasing trend in the direction in which matters have gone. But that is the subject for another day and another debate. But thank you all so much for joining me. You've been a great panel. Thank you so much for watching Reality Check. Good night.